name is Nicholas Bertzel. I'm the Executive Director for the Osteopathic Physicians and Surgeons of California. In my day-to-day job, I oversee the association staff.
Okay. Oh, I found something else is log.
Oh, we got it.
Those log.
There we go. Sorry about that. Where I oversee the association, general governance, and oversee our legislative program. Joining me today is Jeff Gazzo, principal at Gazzo Strategies and Campaigns. He's also the campaign manager for the No on FIPA. We don't have a number yet, Jeff, so I'm just going to say No on FIPA, right?
No, that's perfect. Thank you.
All right. Jeff is the campaign manager for the No on FIPA campaign, Protecting Micro, which we will have more information on later on in our presentation. So again, thank you for joining, and we're getting started right now. Today's learning objectives, we'd like you to develop a general understanding of OPSC's advocacy process, develop a general understanding of new e-prescribing requirements, develop a basic understanding of current California politics, understand OPSC's 2021 legislative priorities, and understand the Osteopathic Medical Board's sunset review process. So as I mentioned before, OPSC has an established government affairs program, starting with our legislative committee process. And this is really how we reach out, identify, and hear from physician leaders across the state on issues that are pertinent to osteopathic medical care. Once we get those issues, we send them to the legislative committee, who then meets and sends recommendations to our board of directors, who then takes that recommendation, discusses amongst themselves, and then either passes or decides not to support or oppose a bill. In our operation, we have a lobbyist, Matt Back, who is unfortunately unable to make it today due to a previously scheduled commitment, and then myself and your physician leadership. So that would be the OPSC officers, past presidents, and then anybody who serves on the legislative committee. We generally work with what's called the House of Medicine. That's the aggregate of all the physician organizations. A lot of times the financial institutions will join us in the House of Medicine, and same with the allied health professionals. So when you hear that term House of Medicine, kind of think of the overall physician community. And then obviously we have a political action committee, which we maintain for the association and support candidates who are supportive of our core legislative and political issues. So, let me move this. So California has a 2-year legislative session. We just wrapped up the first year. We did get some new legislators for 2021. Democrats still maintain a large majority in the assembly, and my numbers actually may be wrong. I don't remember if I updated this, but 59-19-1, I believe that's correct. Jeff, do you know offhand?
Yeah, I believe that's right, based on the vacancy. Yep.
Yeah. We've just for some background, we've had some vacancies and some special elections. So very exciting time in California politics. We'll get into that a little bit more as we move forward. 2021, clean slate of legislation. Over 2,000 bills were introduced over this last legislative session. That's a staggering number, especially considering that a large portion of them did deal with healthcare issues. Now, I mentioned our legislative committee and board of trustees process for going over this legislation. Generally speaking, Matt and I will send a couple hundred bills to members of our legislative committee, and that list is narrowed down to about a handful, which is what we feel comfortable as an association really advocating for or against. It was an interesting year, to say the least. Thankfully, Matt Back was the one that had to deal with the capital COVID-19 protocols, but to put it bluntly, traditional lobbying has gone out the window. You're having to do it a lot over Zoom, like we're doing today. You're having to do a lot of phone calls. Maybe you get some face-to-face meetings, but nothing like you had in the past. So lobbying has definitely changed for those of us who spend a lot of time in the legislative arena. So jumping right in it, 2021 is the year of the sunset for OPSC. We're really excited. We've spent a lot of time working on a major issue for osteopathic physicians, and that is the CME requirements that you all have to get to maintain your licensure. We went to our committee process after hearing from a number of individuals who desired to have the requirement changed. We took that to our CME task force, who then sent a recommendation to the OPSC board of directors to change CME requirements. We went through that process. The board passed that proposal, and Matt Back and I went to work in the state capitol. Inevitably, the vehicle we used to secure the CME change is Senate Bill 806. by Senator Roth. He is the chair of the Senate Business and Professions Committee. Sunset review processes are in the legislature. That's how the legislature reviews the appropriateness of a certain board or committee. So within the language of the Osteopathic Medical Board, we have every 4 years, we go back to the legislature, send a report to the legislature on how we've been doing as a board and as a profession, and ask the legislature for any changes to statute that we may desire. The process engagement, again, full year long of lobbying. Most important parties, Senator Roth, obviously legislative staff and the legislative analyst's office who we worked with to make sure we got the language correct in the new update. So without further ado, for those who haven't seen it or heard or seen our updates, your new CME requirements beginning January 1st, 2022 are as follows. 50 total hours of CME, 20 of which must be AOA 1A credit. Now your two-year cycle remains unchanged. So that is a 50% reduction in CME requirements across the board. We're really excited to be able to deliver that for our members and get you guys some regulatory relief, because we know that that's been an issue for quite some time. Just offhand, MDs in California are only required to get to 50 hours. That's where we kind of benchmark the total off of. The legislative committee did find it appropriate to maintain some AOA 1A credit requirements. That's where we got the 20 hours. And inevitably the board and the CME task force thought that 10 hours every year or 20 hours total was a reasonable request to maintain the distinctiveness of the osteopathic profession, which I know Dr. Nguyen is joining us today. That was his focus as president. So we're really trying to stay committed to being a distinct profession at OPSC and in osteopathic medicine. Another regulatory change of note, beginning January 1st, 2022, all prescriptions issued by a licensed prescriber will need to be done electronically. And I'll say that one more time for everybody in the back. Beginning January 1st, 2022, all prescriptions issued by a licensed prescriber will need to be done electronically. We've been getting a lot of calls requesting information on who is exempt. There are exemptions, and I'll get into that, but a general rule of thumb is if you are a practicing physician in California, you are probably required to submit these prescriptions electronically. Under this law, a healthcare practitioner who does not use an e-prescription to issue controlled substances prescription shall document in the patient's medical record the reason you didn't prescribe electronically within 72 hours. So again, states taking this very seriously. The law is partially based on the Medicare electronic prescribing for controlled substances requirement, the EPCS requirement. But again, California's law much more broad. It captures all prescriptions, not just controlled substances. Yeah. Exemptions do apply, like I mentioned previously. Some exemptions that are on the list, if the prescription is issued to a terminally ill patient, if there's a technology failure, but again, remember that documentation rule, the 72 hours, you have to put in the chart that there was a technical failure. The dispensing pharmacy is out of state. The prescriber and dispenser are the same entity, or you're in an ED or urgent care clinic. And again, there are some additional exemptions. I urge you to go onto the OMBC's website or the Medical Board of California's website to make sure you have a handle on those. But again, a general rule of thumb is if you are a practicing physician in California, you are required to use e-prescribing.
Nick, are you taking questions as you go?
I was going to do them at the end, but I'm happy to take a question right now because we're running a little bit ahead of time.
Okay, because I work with hospice and palliative care, and that sentence of the prescription is issued to a terminally ill patient. We were trying to figure out, we get the hospice side of it, but the palliative care side, you know, my staff, the physicians write prescriptions for our palliative care patients for them to take to the pharmacy, and they're not really set up in our system. So I was trying to look at the law to get that exact information to see if it's palliative care and hospice care. So anyway, I didn't know if you knew.
Let me look. I have some. Give me 1 second here.
And you can always tell me later if it's
yeah. Let me reach out later, because I think there is a distinction. I think there's a technical definition of what they're calling terminally ill patient. So I'll get back to you on that. And that's a good reminder for anybody on this webinar that has questions about e-prescribing or anything else for that matter. Please do feel free to reach out to us directly. There's generally someone to answer the phone at the office. If not, you can email opsc@opsc.org. But one of the main services we provide is literally this, where if we don't have the answer ourselves, we'll get you to the person who does have that answer. So just a general reminder for those on the call.
Thank you.
We have gotten some questions, especially from physicians who do not use an EHR or do not have an online any kind of system. Again, you do have to use e-prescribing in your practice. We recommend a free low-cost option if you're really looking for something that's free or low cost. It's called iPrescribe. It does fulfill all the requirements within e-prescribing, but again, it's going to be a limited system because it's free or to no cost. So again, it's an option for you. It's not officially endorsed by OPSC, but it's something that we've been sending our physicians along to should they not have a solution and not have the budget to bring along a full EHR with e-prescribing capability. For those that do have an electronic health record set up, most of the systems, it's a flip the switch if you're not already using e-prescribing. We do recommend that you can, if you're looking for a system, we recommend that you consider electronic prescribing systems that are connected to the SureScripts network, which is the most robust network of dispensing pharmacies. So just a little bit of a note for us, but again, this is more for folks who don't have a EHR and don't have the budget to bring along something a little bit more robust. Now, moving to what I think is our most important topic for the next foreseeable future until November 2022 is a general attack on MCRA. And there are going to be a couple things we'll go over. One is the legislation we opposed, SB 447 by Senator Laird. And then the next is FIPPA, which is the ballot measure that's being pushed by consumer attorneys. So just to start, Senate Bill 447 was authored by Senator Laird and sponsored by the consumer attorneys of California. Those are the trial lawyers, of course. Just about every legislative session, they introduce a series of bills that somehow affect MCRA in an effort to chip away at the edges of MCRA in preparation for a more extensive threat like we see now. This bill is no different than that example. Again, authored by Senator Laird. It takes, so in law right now, if a patient is deceased, their representatives or family members are not able to sue for non-economic damages, pain and suffering, and so on and so forth. This bill, which was unfortunately signed by Governor Gavin Newsom, will allow representatives or family members of a deceased individual to seek pain and suffering damages in the event of a medical malpractice case. Again, like I mentioned before, this was opposed by the House of Medicine, including OPSC. It's something that I serve on the cooperative Californians Allied for Patient Protection CAP, which is the MCRA Coalition. I serve as their legislative chair for the legislative committee, and it's something that we were very active in opposing. But again, unfortunately, for a number of reasons, the bill was able to get out of both houses of the legislature and was inevitably signed by the governor. Anecdotally speaking, the feedback that I got from the building and elected officials that I spoke to was that they understand the importance of MCRA, but that this seemed like a reasonable amendment to the current law based on what they've seen historically in regards to the cost of medical malpractice insurance and their sense of what's fair when something, if something happens in a medical malpractice suit. So again, that law was signed by Governor Newsom. I expect that it will have a negative impact on medical malpractice rates across the state. But again, much more closely aligned to the overall effort by trial attorneys, consumer attorneys, and an individual who filed a ballot measure to attack MCRA. And with that, I'm going to hand it off to my colleague, Jeff Gazzo, to do the presentation on the ballot measure. Let me stop my screen share. While I'm setting this up, I want to open it up for any general questions real quick before we move forward. Any questions on the legislation or regulation that I went over?
Nick, I will tell you, I looked at that iPrescribe and filled out to get it. And I'm now in week 5 and still have nothing. So just if this is really effective January 1st,
Yeah.
Assuming I'm not an oddball for some reason and it's taking them a longer period of time, it's good for people to know that this doesn't happen overnight.
I will, yeah, so that is a great point. That's the first time I've heard that. I know that the world is running about a month behind, it seems. I'm in the car buying process right now, and it's very much a similar case. But that's an excellent point. Do not wait. It's one of the reasons we've been getting so much information out and really hammering this point home. If you wait, you're putting yourself into a precarious position in regards to being able to prescribe at your practice. Dr. Nguyen, I see your hand up as well.
Yeah, hey, Nick, I was just wondering, does that electronic prescribing pertain to workers' comp as well? Is that a requirement for everything across the board?
Yes, that's my understanding. Unless you're in the urgent care ED, and I don't have the specific definition of even that. I think there's a little bit of leeway in there, but I'd have to look.
Okay, just wanted to make sure. All right, thank you.
Yep, no problem. All right, Jeff, are you ready? I made you a co-host.
Thank you. I'm going to share my screen here. Great. Well, thanks, Nick, and thank you all for having me here today. My name is Jeff Gazzo, and I'm the campaign manager for the effort to defeat this dangerous ballot measure. And I say dangerous because this measure really is way more than just a ballot measure that raises the cap on non-economic damages. The so-called Fairness for Injured Patients Act, or FIPA for short, because I really have trouble using those words as a describer for this measure, is going to go before voters in November of 2022, next year. It's absolutely qualified and will appear. But FIPA is very different from Prop 46 that you may remember from 2014. Prop 46 was presented to voters as an initiative that said, and this is the exact language that was drafted by the Attorney General, drug and alcohol testing of doctors, statewide database of prescriptions, medical negligence lawsuits. FIPA instead is going to be presented to voters as a just limitations in medical malpractice lawsuit. This is the title that voters will see when they choose yes or no on their ballot. And those differences mean we'll have to have a very different conversation with voters. And while much of the focus is on the fact that this ballot measure would raise the $250,000 non-economic damages cap to approximately 1.3 million and adjusted for inflation every year thereafter, the measure is actually craftily written to blow up MICRA altogether. That's because the ballot measure would create a new category of injuries called catastrophic. And catastrophic injuries are defined as any level of permanent physical impairment, disfigurement, disability, or loss of consortium. So with a definition like that, it's been almost impossible for us to find any injury that wouldn't qualify as catastrophic. And every future claim then would be filed as catastrophic because that category means the non-economic damages cap does not apply. It means the attorney's fee limits do not apply. And a catastrophic injury, actually, a classification imposes a one-sided provision as well that would require the court to make an attorney's fee award on top of the damage award. Right, so that's not available to the defense, only to the plaintiffs, right? So once that award is figured out, they would come in and figure out the attorney's fees to layer on top of that instead of coming out of the award. So who's behind this dangerous measure? The main proponent for FIPA is not the consumer attorneys, that's the trial lawyers Nick mentioned earlier, who were the lead organization behind Prop 46 in 2014. But instead, an out-of-state trial attorney named Nicholas Rowley. To date, Rowley's contributed more than $4 million of his own money, and he said he'll spend a total of $10 million while committing to raising another $30 million. That's definitely a significant amount of money for that yes campaign. Raleigh's affiliated with the firm in Denver, and he runs his own law firm in Iowa, where he's actually stopped legislation to close a loophole in Iowa's medical malpractice law. He's an eccentric jet setter, so I guarantee you're going to be hearing and learning more about him in the coming months. To date, FIPA's raised about $5 million, most of it from Raleigh himself, and the other donors have clear ties to Raleigh, buddies, people he's tried cases with, etc. And as you can see, most of that money isn't even from California. So we know this isn't the same measure as Prop 46, and we know Raleigh won't run that same campaign they ran, but it's also important to note that electorate in California has changed dramatically as well since 2014. In 2014, we saw the lowest participation rates in any regularly scheduled general election since they actually started keeping track, which they go back to 1910, more than 110 years ago now. Another thing that 2014 saw was that Governor Brown's sleepy re-election, while the actual big candidate fight that year was around the state superintendent of public instruction. And when it came to the ballot measures, Prop 46 was arguably the most high-profile measure on the ballot that year. But 2020 will be different. I'm sorry, I think I jumped a slide here. But 2020 will be different, right? We've got Governor Newsom's re-election. We have Senator Padilla's first election, AG Bontas, Secretary of State Weber, all going before voters for the first time, right? We've got razor-thin margins in the House of Representatives. So, right, Central Valley and Orange County congressional races are going to drive excitement and intensity, at least in those regions. You know, the electorate's just different too. There are 2.5 million more Democrats registered to vote in California than in 2014. And Republican voter registration growth lagged, adding only about 500,000 more Republicans. And that increases the net Democratic registration advantage from 15.2 to 22.1%. I mean, that's a massive shift in 7 years. Recent election administration changes in the law will also continue to help juice turnout. Sending every voter a mail ballot, having early in-person voting. These are all things we now have that weren't available in 2014. And in the recall election, while it started as a low salience election, turnout actually ended out being 58%, which is incredible. And lastly here, the 2022 ballot looks to have more well-funded measures than 2014. The 22 ballot starts with a few measures left over from last year. In addition to FIPA, you also have the tribes have a sports wagering measure. There's a plastics initiative and a referendum on tobacco legislation. But there's a lot more in the pipeline, including measures on school vouchers, collective bargaining, initiative reform. The dialysis measure is coming back again. Dams, the death tax, local land use, and at least 2 other sports wagering measures. So with this much at stake, the campaign's executive committee brought back the core team from 2014, including lead consultant Gail Kaufman, creative team of Dixon Davis Media Group, and pollster David Binder. Our campaign team is currently conducting policy research to truly understand the full financial impact of FIPA, right? That's really important because the Legislative Analyst's Office provides key data points on the fiscal impact to voters and what the cost is of this measure, which we believe is very significant to both state and local governments. And we're also conducting opinion research to communicate a winning message to the electorate that's also going to be different from 2014. In that early public opinion research, we've learned some key things. First, that voters really can't differentiate between the differences between an economic and non-economic damages. And they're very surprised, quite frankly, that the existing cap of $250,000 is so low. And when learning that that cap hadn't been increased since 1975, it really does fuel sympathy for that position. They don't really understand or know what the amount should be, but a number that was set in 1975 just doesn't settle for them. So what does that really mean for our campaign? It means that we, as a no campaign, must set the tone and define this issue. While this is a totally different measure than Prop 46, the goal of that campaign was the same. First, to help set the tone, we must have a unified, organized, and active coalition. To date, our coalition already has almost 400 organizations who've endorsed a no vote and is growing every week. We secured the endorsement of every Republican state legislator so far, as well as an official no endorsement already from the Republican Party. So it's nice to have that side of the aisle wrapped up and with us on this. But even more so, apologies, jump in there. But even more so, in order to set that tone, we must be able to raise the resources. And so while the election seems like it's far off, it really isn't. And it's going to come quicker than we realize. So that means there are some things that you can do right now to help us. First, if you haven't already done so, personally, please endorse a no vote. You can do that at protectmicro.org/join. I can drop that link as soon as we're done here into the chat. Also, in the beginning of the year, we're going to be holding our third virtual, what we call ambassador trainings. This training's tailored for our coalition members just like you. The seminar will provide an overview of the ballot measure, as well as some key messaging and engagement strategies. And so I'll drop that link into the chat. And if you're interested in signing up, we'd love for you to join that to get you into this ambassador program. So we've got a lot of work ahead of us. The elections can come quicker than we all think it is, even though it's a year out. And we really do appreciate your time, support, and allowing me to come today. So thank you.
And I'll take it back from Jeff. I was part of the team that worked on Prop 46 last time around, and Jeff's points are great. That it's going to take a lot of money, but even beyond that, it's going to take a lot of involvement from the physician community. So if you're on this call, please do access that link whenever it's posted, and join the winning team here, because this is one of those, I hate to say it and I hate to sound, sky is falling, but this is one of those dire need situations. So all hands on deck. We appreciate your guys' support and help. If you could do that financially or with your time, that's what we need from you, and that's what we're asking. With that concludes the presentation portion of the program.